Hi, Attorney Robert Eckert here, your board-certified business litigation attorney and government investigation specialist. Today I want to talk about how to effectively utilize non-compete agreements in a tight labor market. As most employers know, human capital is currently a very precious commodity, and employers are using legal tactics to retain their star performers. One tool employers often use to retain high-value employees is something called a restrictive covenant or non-compete agreements. These non-compete agreements seek to prevent an employee from going to work for a competitor and taking that previous employer's legitimate, valuable business information with them and using it. With so much movement in the job market lately, efforts to enforce non-compete agreements have skyrocketed. So it's important to make sure that your documents are enforceable and that you comply with current laws and the best practices. Some background on non-compete agreements exist, in large part, to protect an employer's customer relationships, confidential information, trade secrets. Customer relationships, of course, are the lifeblood for a for-profit company. If an employer has entrusted an employee with maintaining a customer relationship, that relationship is often called a legitimate protectable interest, or an LBI. A company's confidential or proprietary information or trade secrets may include intellectual property, such as inventions, formulas, trade secrets, things of that nature, as well as a company's business plans, pricing information, or non-public customer lists. The question is, will that non-compete agreement hold up? Having an employee sign a non-compete agreement is one thing. Enforcing the restriction is quite another. If an employer can establish that it has a legitimate, protectable business interest, an LBI, in certain valuable, confidential, non-public information or unique customer relationships in which a former employee had access, then a court's more likely to enforce a non-compete or non-solicitation agreement. The latter is similar to a non-compete, but instead of preventing a former employee from working for a competitor or in a particular field, it prevents the former employee from soliciting customers or former employees from their former employer. If the employer cannot establish a legitimate business interest to be protected that requires that necessary court intervention, then the agreement's not likely to be enforced. Courts will scrutinize an employer's claimed interest to ensure that it is actually one involving a legitimate business interest to be protected and not merely an attempt to keep its former employee from working for a competitor. The restrictive covenant also has to be reasonable in scope, meaning the legitimate business interest has to be reasonable in terms of the length of time and the geographic location in which the restraint applies. In Florida, the word reasonableness, or a derivative, occurs within the statute, chapter 542.335, at least 17 times. What is considered reasonable varies from jurisdiction to jurisdiction. The current trend is for states to limit or even prohibit non-competes in terms of time, types of employees that can be restrained, and certain professions, or whether an employee has been terminated or quits. The past few years have seen numerous attempts at limiting or banning non-competes in many states, and there was even a bill at the federal level proposed limiting non-competes in 2021. That bill was defeated. Where a bill limiting non-competes was introduced in 2021 but did not pass Congress. Employers should limit who signs a non-compete agreement. The more specialized an employee's role, the more likely it is that the non-compete agreement will hold up if the employee leaves to work for a competitor. That's because higher level, more specialized employees typically have access to sensitive or confidential proprietary information or have customer relationships, whereas an administrative assistant, for example, cannot hurt the employer by going to work for a competitor because their skills are interchangeable from one employer to the next. And while they may have access to confidential information about customers, they typically cannot use that information in a competitive fashion. When properly executed and the restriction is reasonable in terms of geographic time, scope, and legitimate business interest to be protected, non-competes can be an effective tool for protecting a company's interest in retaining talent. And in a tight labor market, flexibility, customization, and ensuring that the document is legally enforceable can provide an employer with some comfort that when it lands its next big hire, that employee cannot later use that information that it gained from the employer against it to weaponize itself and its next employer against the former employer. the confidential information and customer relationship in which the employee is entrusted against the company. Recent case law from the 5th District Court of Appeals in Florida, filed December 22nd, 2022, the Vessels and Coast to Coast Terrazzo LLC. In that case, the appellate court reversed the trial court and said that the central issue in the appeal was whether the plaintiff proved that the injunction enforcing the restrictive covenants contained in the agreement was necessary to protect the legitimate business interest. The defendants argued that the knowledge that Vessels gained while employed by the plaintiff is neither extraordinary nor specialized, nor worthy of protection by the covenants, and merely an attempt to prevent ordinary competition. The 5th District Court of Appeals in Florida held that the trial court committed error by entering the preliminary injunction enforcing a non-compete agreement because the plaintiff, a Terrazzo Restoration Company, attempting to enforce this non-compete and restrictive covenant, and the restrictive covenant contained in the agreement was necessary to protect a legitimate business interest. The appellate court also held that the evidence did not support a finding that the plaintiff had provided defendant with specialized or extraordinary training, where the evidence, even when construed in the light most favorable to the plaintiff, established that the defendant received on-the-job training that was usual and the regular, common, or customary in the industry. A few of the facts of that case are this. The trial court entered a preliminary injunction in favor of the plaintiff and against the defendants. The court found that the Terrazzo Restoration requires specialized skill and training, and that the defendant, Vessels, acquired a great deal of knowledge regarding the repair and restoration of terrazzo floors during his employment with the plaintiff. It further found that the appellee, or the plaintiff, proved a legitimate business interest worthy of being protected by the injunction without an adequate remedy being available at law for the plaintiff. In an action to enforce an agreement that restricts or prohibits competition during or after the term of the restrictive covenant, they must show that the person seeking enforcement of the restrictive covenant shall plead and prove the existence of one or more legitimate business interests justifying the restrictive covenant. The term legitimate business interest includes, but is not limited to, trade secrets, as defined by Chapter 688 of the Florida statutes, valuable business or confidential or professional information that does not otherwise qualify as trade secrets. 3, substantial relationships with specific prospective or existing customers, patients, or clients. 4, customer, patient, or client goodwill associated with an ongoing business or professional practice by way of trade name, trademark, service mark, or trade dress, a specific geographic location, a specific marketing or trade area, extraordinary or specialized training. Any restrictive covenant not supported by a legitimate business interest is unlawful, void, and unenforceable under Chapter 542.3351. Although the trial court did specifically identify the legitimate business interests under the statute on which it based its preliminary injunction, the allegations in the complaint, the language used by the court when making its factual finding, and counsel's arguments in this appeal suggest that the appellee's legitimate business interest being protected was that Vessels received extraordinary training. In order for the training to be a protectable business interest, it must be extraordinary. And that's the Dyer case out of the 2nd District Court of Appeals. If you have any further questions in reference to non-compete agreements, business litigation, or any government case involving investigations, please feel free to contact me at the number on the screen. Thank you and good luck.